Yes.
I'd like to mention item number 8, Your Lordship. The petitioner has expired in the date of 21, Your Lordship. Kindly a request is called from the misconduct.
It's fixed today for dismissal.
Yes, Your Lordship.
In the order matter, wait. Wait for your turn. Yes.
Item 12 and item 16.
Huh?
Item 12 and item 16.
12.
16. The engaging counsel is out of station. After
Hmm?
for any day.
What happened? 12. What do you want?
Adjournment.
For who's the leading counsel?
Mr. Anuddin, Nasiruddin.
Is out of station.
Yes. After for any day.
Have you informed the other side?
No.
Why are you all making mentions without informing other side? Do you know the consequences if you do not inform the other
I
side?
tried to call yesterday. Lord.
Do you know the consequence? What? The other side counsel will be sitting here unnecessarily waiting for the matter to be called because he is not informed. Correct? And then when the matter is not called, he'll be taken by a surprise. Is that fair to the other counsel?
I will inform them.
So please inform. No, you inform and then make mention. Now you wait for your turn. If you cannot find the counsel, doesn't mean that you come and make a mention. Then you have to wait for your turn to come. When your turn comes, this court shall always accommodate you. But you'll have to wait for your turn. Yes.
Yes, Mr. Lexit, item number 21, Madam Chief. Engaged counsel clears Srinivasan sir, health condition is not, health condition is not well. So, Madam
Who's
Chief,
not well?
clears Srinivasan.
T.N. Srinivasan.
Madam Chief, after the guru.
Your name?
And
Mr. N. Islam, learned counsel for the petitioner, informs that the conducting counsel, Mr. T. N. Srinivasan, is indisposed and accordingly seeks accommodation in the matter. Prayer is not opposed. Relist after 3 weeks on a date to be fixed by the registry.
obliged.
Yes, call the list.
Item number 1. Case regarding negotiable instrument, other than several installments, we have finally cleared the amount.
Oh, it's
Yes.
cleared.
You have done received.
So we can close it and only closing would be sufficient, or we'll have to, I think,
Set aside that.
set aside that order. Which is the order?
And page 14, the order of the magistrate,
Page
14, 1-4.
14.
Operating is 20, but 14 is start level. Here 4353.
1 second, 1 second. This is the magistrate court's
Yes, madam.
order on 24/8/17. And operating is
Operating is matter 2020.
did you file an appeal against this? No.
No.
Straight away the revision.
Revision, but I appeal with a 5.
Correct, correct. Which is that order?
That order is matter page 23. And operating is 36.
Okay, I think I'll get the reference in the prayer also.
Yes. Yes.
That is 4619.
49.
All right. Heard Mr. B. Chakraborty, learned counsel for the petitioner. Stop. Also heard Mr. K. Kothari, Y. Kothari, learned counsel for the respondent number 2. For respondent number 1 and Mr.
One.
P.K. Parashar, learned APP for the state respondent. This revision petition is presented against the judgment and order dated 24/8/2017 passed by the learned judicial magistrate first class Kamrup M in CR case number 4353/2013, whereby the petitioner was convicted under section 138 of the Negotiable Instrument Act and was sentenced to undergo simple imprisonment for 4 months and to pay compensation of rupees 15 lakh under section 257 CRPC with a default clause. And the judgment and order dated 4/6/2019 passed by the court of
Additional session, sir.
passed by the additional session judge FTC number 4 Kamrup M in criminal appeal number 219 of 2017, dismissing the appeal filed by the petitioner. Stop. Mr. Chakraborty, learned counsel for the petitioner, submits that during the pendency of the revision petition, the petitioner has
Take the entire 15 lakh.
paid the entire compensation of rupees 15 lakh as directed by the magistrate court. Stop. Mr. Y. Kothari, learned counsel, appearing for the complainant, stroke R2, confirms the same. It is further submitted at the bar that since the payment in question has already been paid,
The matter has been compounded.
where
Compromised.
and the matter has been compromised between the parties. Therefore, the impugned judgment and order of the magistrate court as well as the appellate court may be therefore there is no no adjudication is required in the present revision petition. Stop. In view of the endorsement made by the learned counsel appearing for the parties and in the interest of justice, this court closes this revision petition in view of the compromise arrived between the parties and keeping in mind that the petitioner has already compounded the penalty imposed by this court, this court set aside and quashes the order dated so and so of the magistrate court as well as the judgment and order dated so and so of the appellate court. Matter stands dismissed. Matter is disposed of. I in the what is the
I was regarding compounding, I initially filed it. That may be closed off.
in view of the so and so, the I also stands disposed of.
Number 2.
Hello, may I please your lordship?
Yeah.
Hello, the matter related to the maintenance, my lord, awarded by the learned court below, my lord. We are against that order, my lord. Now, as per the direction of the learned court below, my lord, we are regularly paying the maintenance, my lord. So let the matter be come up for a final hearing, my lord.
But it is not true. We have received the maintenance after November 26.
Yes,
Where is the order? Which order you are challenging?
my lord, yesterday, my
Which is
client
the order that is under challenge?
order, my lord, impugned judgment, my lord, at page 9, my lord, annexure 1.
Let's see whether there is any case for admission or not.
Yes, sir.
A revision petition cannot be admitted mechanically.
My lord, yesterday, my lord, my client has deposited
It
32,000.
is a different matter. This is a matter of 2019 which has come up for admission. So first you make out a case whether admission is required, not required. Mr. Jain, right?
My lord.
So Jain, page.
So, my lord, for that, my lord, sometime maybe.
Why?
I am not yet prepared, my lord.
When matters are listed specifically, especially the old matters,
My lord, sorry, my lord.
this
After
is not expected.
After a week, my lord,
Why- why
I have
after
not
a
gone
week?
through the evidence.
Please let us go to that judgment.
Judgment, my lord, at page 9.
Yes. This is,
We are claiming, my lord, we are claiming in this case, my lord, that the second party, that is the wife, is not a legally married wife. my lord.
all
The
right, let
basis
us
of
see. What is given is maintenance.
Maintenance.
You read from
Page 9 is the judgment, my lord.
page 10, you read, I have heard the parties.
I have heard the parties and also perused the evidence.
Page 11, point number 1.
Point number 1. PW Sabita Bora in her evidence claimed that she got married to Sunendra Bora in the month of August 2016 and had been living with the Sunendra Bora as a husband and wife for around 7 months. According to PW1, during these 7 months, her husband Sunendra Bora had asked her to arrange 50,000 in cash from her parents. PW1 having failed to comply, she had been thrown out by her husband. Since then, she has been living at her parents' house. In spite of earning around 35,000 per month from his computer shop in Guwahati, the second party had neither visited nor extended any financial assistance to her, knowing very much that she has no other sources of income or substances. In his cross-examination, the first party claimed that her marriage to the second party had been solemnized in the courts of Guwahati. PW1 admitted having brought a criminal case against her husband for the alleged unlawful demand by her husband of rupees 50,000 in cash. That case has been disposed of by acquitted the petitioner. PW1 further claimed one of her cousin Kamal Boro to be the close neighbor of the second party, and from the time to time he used to come for her cousin house. PW1 claimed not knowing Sunendra Bora earlier to her marriage to him. PW1 further deposed not being aware that Sunendra had already been married to one Meera Boro and had a son Lucky Boro from the said marriage. PW1 denied the suggestion that she and Sunendra Bora had never been married.
Sabita Bora.
Sabita Bora is the first wife, my lord. Wife, it's the wife of the petitioner, my lord.
You are for the first wife.
Second wife.
No, wife, not second, I know wife of the. So he's claiming that I am the second. But
Now Sunyan Bora is the
Son.
that she got married. He is the husband.
Husband. Sunendra Bora is the husband.
Husband. And who is the complainant?
Complainant.
Sabita Bora.
Sabita Bora.
Sabita Bora is the complainant.
Yes.
The Sabita Bora is claiming the maintenance.
Yes.
Right?
Yes. Sunendra Bora had never been married and alleged that Sunendra demanding rupees 50,000 from her is not true. PW1 denied the suggestion that she is not entitled to claim any maintenance from second party. During re-examination of Sabita Bora, PW1 claimed that she has a 11-year-old son sired by Sunendra Bora. Since her son
The
had been
second that she was prior to entering into a marriage or living in relationship with PW1, is it an admitted fact that Sunyan Bora already had a wife?
yes, madam.
That marriage is proved.
Yes, madam. Marriage.
No, aware, not aware is another thing, but that factum of
Yes,
the first marriage is admitted.
Yes, madam.
Now, in that situation, even assuming there was a live-in relationship, but one of the condition is to see that the marriage was qualified to marry. Now, if there was a spouse, then that marriage could not have happened.
thing is that first marriage, as they are claiming now, they have their.
You were not aware.
Yes.
Correct, but then it comes out that he
And
was.
that also not the.
Anyway, then I'm admitting it.
Logic में admit सबसे important है they will very clear.
My lord, I have the screenshot of payment, my lord.
All right. Which is the order there was no stay order here.
There is no stay order, ma'am.
Heard Mr.
SKJ.
S.K. Jain, Learned Counsel for the petitioners. To have also heard Mr. J. Kalita, Learned Counsel for the respondent number sole respondent? For the sole respondent, stop. Petitioner has made out an arguable case, admit no formal notice as parties are represented. Mr. Kalita has submitted that though initially maintenance as per the impugned judgment has been monthly, comma, the petitioner has been paying. However, after November,
After November 2023.
after November 2023, he has, the petitioner has stopped paying the,
Well, yesterday I,
one second.
Madam.
Why don't you hear what the court is saying? I'm recording the submission.
sorry, madam, sorry,
Why do you keep interfering?
sorry, madam.
What did I say? No, from the beginning of the sentence. Paying the maintenance as per the impugned judgment. Stop. However, Mr. S.K. Jain, counsel for the petitioner, submits that he has received instructions.
Yes, my lord. Yesterday itself, my lord, 32,000 paid.
That is the entire amount or what?
Only balance amount, my lord. As per my instruction, my
But
lord.
that the balance amount of rupees 32,000 has been deposited
Deposited in her account.
in the account of the respondent. Stop. However, Mr. Kalita admits that he has no such instruction. Stop. Be that as it may, since there is no stay against the impugned stay order, since this court has not granted any stay, has not stayed the operation of the impugned judgment in order, comma, the petitioner is is directed to strictly comply with the term with the direction contained in the impugned judgment and order dated so and so. Stop. In case they don't, then you come up with a contempt. Failing which consequences in accordance with law shall follow. List after 3 weeks on a date to be fixed by the registrar for hearing.
Admitted for hearing.
Yes, next. Mr. Jain, please listen to the orders of the court. Be mindful. You are not, you must be, one must be mindful where one is standing. Don't unnecessarily say things which is not necessary. Yes.
Oblige.
Item number 3, anyone? Mr. Biswas, you are appearing in item 3?
I have an activity and also taken steps to see.
In item
There are
3.
4% have been already expired.
In item 3,
It is 3. Sorry, sir.
because your name is not there. None appears with the petitioner on call. Stop. I know, Mr. Parasar. Wait. The matter is listed today, Mr. Parasar, with a remark. Have you seen the remark in the cause list? I understand the anxiety that goes that side, but have some faith in the court also. What did you write? On call. Heard Mr. K.K. Parasar, Learned APP for the state respondent. Stop. It appears that since there was no representation on the last occasion, I 27/3/2025, comma, and 4/3/2025. First you say 4/3/2025 and 27/3/2025, comma, this court directed listing this matter today in the order column with the remark with reports for dismissal. However, today also, when the matter has been listed, showing the names of, reflecting the names of 3 counsels for the petitioner, none is present when the matter is called. As such, the revision petition stands dismissed for non-prosecution. You want to say anything, Mr. Parashar? Anyone appearing for the petitioner in 4? None appears for the petitioner when the matter is called. It appears that on the last occasion, i.e. 28/3/2025, also there was no representation on behalf of the petitioner when the matter was called. Accordingly, the matter was directed to be listed today in the order column with a remark with imports for dismissal. However, despite the matter being listed with the aforesaid remark and the names of 3 learned counsels appearing for the petitioner being reflected in the cause list, there is no representation on behalf of the petitioner. In view of the consecutive non-appearance of the learned counsels appearing for the petitioner, the criminal revision petition stands dismissed for non-prosecution. Mr. Talukdar, you are for the respondent.
I'm for
Same order, perhaps.
the conviction under 494 items. And concurrent pending or trial could have that.
I'll dismiss it for non-prosecution. Otherwise, this court will have to
Go on merit.
go on merit. None appears for the petitioner when the matter is called. Heard Mr. D. Talukdar, learned counsel appearing for
OP number 1. That's
for respondent number 1 and Mr. Parashar, APP for the state respondent. It appears that since there was no representation on 28/3/2025 when this matter was last called, the matter was directed to be listed today in the order column with the remark for dismissal. Today, when the matter has been listed with the aforesaid remark reflecting the name of 2 counsels appearing for the petitioner, there is still no representation on behalf of the petitioner. Situated thus, the criminal revision petition is dismissed for non-prosecution. Yes, Mr. Biswas, this is your matter.
Acquittal, my lord.
Yes.
During the pendency of appeal, 4 persons died, my lord. We have filed an affidavit. That the honorable court directed us to file an affidavit regarding their death. We
4 have died.
Respondent number 4, 6, 14 and 24.
4,
6, 14 and 24.
4 or 5?
5, 6, 14, 24.
And the rest are?
Just a life pass.
So against this, it will get a better.
Go. Yes, that's right.
When did you file the affidavit?
One report was also called for from the OC.
You have the report.
So, report has not come, I've seen.
You have filed your affidavit.
I filed. But court still wants whether it is there. Court wants to confirm that whether actually they died.
Then you get the report. Then you get
But,
the
we have
report,
taken
Mr. Parashar. All right. It appears that the report called from the OC of concerned PS as regards the death status of respondent numbers 5, 6, 14 and 24 is still awaited. Let a reminder be sent. Yes, you call for it. When can you place it?
But,
All right. Let a reminder be sent to the let a reminder be sent to the jurisdictional police station. Relist on such and such date, the date will be given. You have it, Mr. Parashar. It is needless to be clarified that by the next date of listing, Mr. So and so learned APP for the state shall try to have the report as called for by this court available before this court. None appears for the petitioner on call. Your name?
I will be on behalf of the state with
Mr.
my work.
Y. Barbhuya. Learned counsel for Mr. H. Gupta for the sole respondent. It appears that since there was no representation on behalf of the petitioner when the matter was last called, I 28/3/2025, the matter was directed to be listed today in the order column with a remark for dismissal. Today, when the matter has been listed with the aforesaid remark, reflecting the names of two learned counsels appearing for the petitioner, there is still no representation on behalf of the petitioner. As such, the criminal revision petition stands dismissed for non-prosecution. Mr. Gupta, I'll record your name or his name. Okay, you just say H. Gupta. Yes, you're appearing. Yes. Yes. Who expired? The petitioner. He is the sole petitioner.
A report will be called from the concerned police station.
Uh, Though this matter was listed today in the order column for dismissal in view of the fact that there was no representation on behalf of the petitioner when the matter was last called, I 28/3/2025, however, today MS
S. Nazmi.
S. Nazneen, learned counsel for the petitioner, has appeared on behalf of the petitioner. She further submits that she has reasons to believe that the petitioner had expired during the pendency of the criminal petition. The petitioner expired way back
21.
in 2021. Let a report be called. You will call it, Mr. Mr. Let a report be. Let a report be called from the jurisdictional police station as regards the death of the petitioner through the office of the PP. Relist after 3 weeks and a date to be fixed by the registry. None appears for the petitioner when the matter is called. Mr. Parashar for state responding. You are appearing, right? So and so. It appears that that since on the last occasion, I 28/3/2025, also, there was no representation on behalf of the petitioner. The matter was directed to be listed today in the order column with the remark for dismissal. However, today, when the matter has been so listed, by reflecting the name of the learned, three names of the learned counsels appearing for the petitioner, there is still no representation on behalf of the petitioner. Situated thus, the criminal revision petition stands dismissed for non-prosecution. Ashwin, please check in all these whether there is any stay. If there is any stay, or you write everywhere, in interim, if any, stands vacated. In all these dismissal matters. Yes,
May please, your lordship.
yes, Mr. Kothari, what is this?
Lordship, this is a criminal leave petition under section 378.
Acquittal.
Yes, against acquittal.
Mr. Murali, you are appearing for the
Yes, I am appearing for the
respondent, the accused,
person who was
accused. Yes,
acquitted, not acquitted completely, he was acquitted in respect of some of the sections. And in respect of one section, he was convicted.
leave would be required, I think.
Yes, he will be required. So only thereafter.
Any objection to the
I
leave?
have an objection because it's a frivolous petition. It's absolutely.
Now, why I'm
Yes,
asking you at the beginning is it appears that this leave application is pending since 2016. That is why I'm asking. If we can always hear it on merit.
I don't think.
Hmm?
It is a leave application because
Okay,
then prior to granting leave. Full court has to see whether final.
that's right. So that is why I asked you, if you, anyway. You have filed objection in this?
No, I have not. I didn't.
Uh,
Any objection in the.
no, it's all right. This comes under 378(3).
For as leave is concerned, 378, 4, I believe.
Yes,
Yes, 378, 3 and
yes. Yes, what is your case?
Lordship, basically, the appellant has complained and filed a complaint case before the learned judicial magistrate.
This has come for orders today.
Yes, some for orders.
Leave applications are heard in the order column or can be heard? I can take it up for hearing. Yes.
Lordship, as complainants, we filed a complaint petition before the learned JMFC under sections 420, 403, 422, 424, 427, and 506 of the Indian Penal Code.
Section?
420,
Yes,
403,
yes,
422,
yes,
424,
yes.
427, and
Yes.
506 of the Indian
Huh?
Penal Code. 506.
Yes. And
Sir,
then,
Briefly and upright, what has happened is the accused and respondent introduced himself as a businessman, a wholesale businessman. He wanted to purchase bags of sugar. Accordingly, we dispatched bags of sugar white two trucks. Total 850 bags of sugar were dispatched. In the course of time, he has admitted that he has received those bags. His stance has been that those sugar packages were damaged. But the Lordship will kindly see page 21 of the leave petition, the judgment that we have annexed.
yes,
Page 21, paragraphs 47 and 48.
yes,
Lordship would find paragraph 47, the last. So the Lordship will see the observation that has been made in the trial court by the trial court in the judgment. In such a situation, it is clear that the accused person appropriated the bags of sugar supplied to him. But does the appropriation amount to misappropriation? The prosecution has categorically stated in its evidence that the accused failed to pay the amount due. In his defense, the accused only stated that the sugar was damaged, which he then failed to prove. Since it is clear that no consideration has been paid for the sugar bags, it can be safely assumed that the appropriation was indeed misappropriation. So, Lordship, in the course of trial, the receipt of the bags as well as non-payment has been admitted by the accused himself. The only thing is that he claimed that the sugar was damaged, but no proof to that
No,
effect
but
was.
what is to be seen is whether fraudulent misappropriation or not.
Yes, yes.
This is 506 you are trying to bring.
No, Lordship. So what had happened was, after that, charges were framed only in 3 sections.
Because 420, I don't see any ingredients of 420.
But
I'm
Lordship,
yet to examine, but on the face of it, what you have submitted, not a case of 420. Correct.
Right from
At the
inception,
time of the injection,
inducement has been there.
where is fraudulent intention, dishonest intention at the time of making the promise?
But Lordship, no
And,
date,
and
no
for 506 too, I don't think.
No,
Ultimately,
506.
you were convicted under which section? You said
403.
40?
403.
40
I was supposed to fine of 5,000.
that you paid,
No, against that also, we have filed an appeal
that is pending.
that is pending, but because of pendency of this case.
That has not
Yes,
proceeded.
We may have to call for the request because we separate appeals in different.
No,
forums,
no,
you
we
know.
are not doing all that. This leave application cannot be
Not-
kept
not at
pending like
case.
this.
Not at this
No.
case.
No,
Once,
I am not sure if I'm going to grant you leave,
I
Mr.
understand.
Kothari. You have to make out a prima facie case
Yeah.
for leave.
No.
Yes, then further, let's go down.
so far as the fraudulent aspect is concerned, now what has happened is after the bags were received, payment was not made. The
Mr.
complainant.
Kothari, let us read.
Okay. got it.
Let us read first. Let us see where the evidence are. If reading the evidence, it appears that something is there, then of course.
Also, just grant me a minute or so. I'll just refer to the relevant portion.
No, you come to 51,
Page, paragraph
22.
okay.
Yes.
Yes. 51, as your lordship rightly pointed out, that somewhere I have to show that there was an intention to fraudulently.
Read.
The accused person has also been charged with the cheating under section 420 IPC. However, I find it worth mentioning here that mere breach of contract cannot give rise to criminal prosecution
Absolutely.
for
Nothing wrong.
cheating unless fraudulent or dishonest intention is shown at the beginning of the transaction. That is at the time when the offence is said to have been committed. But lordship may also take note of subsequent conduct. If your lordship would see,
Go ahead, go ahead. Mr. Kothari, let's finish first. You will have all the time to make all the submission that you want.
in fact,
First read.
paragraph 55, the lordship may see.
Read from
Should I
the,
go on from 51?
continue reading.
right.
Don't jump the paragraph.
At the time when the
Mr.
offence is said,
Morali, take your seat.
when the offence is said to have been committed, it is the intention.
Mr. Morali, I need one decision on the power of, the jurisdiction and scope and ambit at the time of, hearing a leave application. If you don't have it, you can ask the junior to just check in his mobile. Yes.
It is the intention which is the gist of the offence. To hold a person guilty of cheating, it is necessary to show that he had fraudulent or dishonest intention at the time of making the promise. Promise mere failure to keep up a promise subsequently, such a culpable intention cannot be presumed. Thereafter, paragraph 52, the learned counsel of the accused has argued that the ingredients of the offence of cheating have not been established against the accused person. He has relied on two judgments, both judgments reported in 2005 CLT.
All right, 54.
54. Lordship. Reverting to the case in hand, the evidence on record does not show that the accused had dishonest intention at the time of making the promise. The transaction occurred in May 2004. There is nothing on record to suggest that the accused person had come with a dishonest intention on that day. And it was pursuant to that dishonest intention that he induced the complainant to deliver the sugar bags. 55. That the accused person subsequently failed to pay the necessary consideration for the sugar bags does not imply that there was dishonest intention at the time he made the promise to pay the money. Conduct, previous or subsequent, is a relevant fact for consideration in any trial or proceeding as per Section 8 of the Indian Evidence Act. The accused person has managed to prove through his exhibits, which were admitted by the manager of the complaint firm, that he had on multiple previous occasions engaged in trade with the complainant, and in each of those transactions, he had paid the necessary payment through demand drafts. It is pertinent to mention here that the learned counsel for the complainant has argued that the fact that the accused person had removed his signboard from his shop, this was what I was trying to refer to, shows that his intention had all along been to deceive the complainant. At this juncture, let me point out the excerpt out that except PW2, nobody else's testimony to that effect that the accused person had removed the signboard is based on their personal knowledge.
What signboard?
Basically, the shop was run on his own name. Ardhan Chandra Shah happens to be the respondent. So it was MS Ardhan Chandra Shah. That shop, when we had gone there, so he had removed that signboard itself. He had
So
changed the
he
identity.
bought the sugar from you
Yes.
for selling it in that shop.
Yes, in that shop.
You are a distributor.
I am a distributor. Accordingly, I sold it. When the payment was not made, I went to meet him, and then I saw that the entire
signboard is
identity
also
has
not
been
there.
changed.
Okay.
As for PW2 statement, even if it is presumed to be true, the fact remains that he went to Agartala more than a year later. That does not in any way prove that the accused person had a dishonest intention to deceive the complainant a year earlier. The absence of any evidence to show preliminary dishonest intention on the part of the accused juxtaposed with his previous conduct shows us a picture in which it can in no way be held that he had the dishonest intention to deceive the complainant at the time. He promised to make the payment. That he later failed to fulfill this promise is a different matter altogether. Situated thus, it is clear that the prosecution has not been able to establish the ingredients, the offense of cheating against the accused person.
All right. Next.
So far as the offense of criminal intimidation, paragraph 50, the complainant side has also brought in the allegation that the accused person threatened the complainant's representative, Sri Vinod Singh, on 19/9/2015. On the contrary, the accused person has denied this allegation. It is worth recalling here that through the suggestions put to PW2, Sri Vinod Singh, the defense raised the plea of alibi.
that the accused was in Chennai at Apollo hospitals at that time, but the defense failed to shoulder the burden of proving this. The defense law. Hence, in such a situation, it will have to be assumed that the accused was not in Chennai on that day. However, the prosecution still has the initial burden of proving that the accused criminally intimidated Sri Vinod Singh. Now, let me see what Sri Vinod Singh has stated in his evidence related to the criminal intimidation. Should I move on to 60 or paragraph 60? Well, this deposing as PW2, Sri Vinod Singh stated that the accused person threatened him that if he did not leave Agartala, he would face troubles. The definition of criminal intimidation as given in section 503 IPC deals with the threat of injury to a person, his reputation or property, or the to the person reputation or property of anyone in whom that person is invested. Telling a person that he would face troubles does not come within the ambit of injury to the person, reputation, or property. That is way too vague a statement to come within the broadest of contours of criminal intimidation. Hence, in such a situation, even if the statement of PW2 is taken at face value to be absolutely true, the same does not make out the offense of criminal intimidation against the accused person, the Hardan Chandra Sahu. Should I come on to decisions? 62. Thus, on the meticulous analysis of the evidence on record and after hearing both sides, it appears that the prosecution has been unable to prove that the accused person, Sri Hardan Chandra Saha, on 25/2000 cheated the complainant, MS Ganpati Enterprises, by dishonestly engaging the complainant to deliver 850 bags of sugar to him, and thereby committed an offense punishable under section 420 of 90. Also, the prosecution has been unable to prove that the accused person, so threatened Sri Vinod Singh, the representative of the complainant, with dire consequences and thereby committed an offense punishable under section 506. However, the prosecution has been able to prove that the accused person, so dishonestly misappropriated 850 bags.
According to me, even misappropriation is not there. Mr. Kothari,
Okay.
fortunately that this is not an appeal filed by them against the order. According to me, there is no case of, where is the criminality and what have been entrusted? And subsequently, some payments have also been made.
No, subsequently, previously,
No criminal, or even for, anyway, I do not want to get into that. So ultimately, for breach of trust, the punishment has been given.
no, misappropriation.
Misappropriation,
Criminal
403.
403. In fact, if your lordship will appreciate section 24 of the IPC, it defines the term dishonesty.
Hmm?
Dishonesty, because this is dishonest misappropriation of property. If your lordship will
No,
just
anyway,
appreciate,
that too, I think has already, 64 is in your favor.
24 IPC.
Paragraph
So,
64 is in
paragraph
your
60.
favor.
Yes,
isn't it?
yes. So far as
The
400,
court have held that the prosecution has been able to prove dishonest misappropriation
yes,
and accordingly convicted
yes,
under
convicted
403.
under
So
403.
anyway, that part we are not concerned. This court is not concerned. That part is, you're not challenging that
We are
part,
not challenging that.
correct? You are aggrieved about cheating and criminal intimation.
Thing and the inadequate compensation of rupees 5,000 that we received, although it was held that there was
That is
misappropriation,
the
but
discretion of the trial court. They have given that for appeal. I
we
don't,
challenge that since we were,
yes, my power.
while filing the complaint itself, we have suppressed material factor. So what is their case? They speak of one particular case. This accused person came to their shop along with a broker. He introduced himself, being a leading businessman from Agartala, and on his such representation, they have sent him two trucks to the 850 bags of sugar, and later on, accused refused to pay. When they went to Agartala, they were investigated. That is actually the case. But while trial came out with the evidence, and accused has exhibited about 60 bank drafts, which shows that
There was a
there was
transaction.
transaction running to 3 crores of rupees. It is not the first transaction. And he took the plea that his sugar was damaged. That is why he did not make the payment. And trial court convicted him only on the ground that if the sugar was damaged, did you
informed them anything in writing. So he said that no, I
So
did
that
not
is why
inform them in
convicted
writing. I have
under-
informed them verbally. To that effect, he could not produce any evidence that the sugar was there. So it's a
I don't find
purely-
anything,
Purely civil dispute,
I don't find anything in this.
purely civil
The
dispute.
subsequent act of changing his sign.
What's
code.
up? That takes
That
you
took
nowhere.
place in Agartala.
That takes you nowhere.
That- Maybe
What
he
about
just
those
followed-
transaction?
Lordship, we have not specifically admitted to that. Yes,
It has come by evidence.
Yes,
It has come.
the perfunctory, it was a, if I have
has
to be
come.
fair,
Where was that? Which paragraph? I
point
have
to
seen-
point of.
Yes, page 55. The accused person has managed to prove through his exhibits, which were admitted by the manager of the complainant firm, PW1, that he had on multiple previous occasions engaged in trade with the complainant, and in each of those transactions, he had paid the necessary payment through demand draft. Mr. Bharali, any decision? you've got?
Appeal against acquittal is to be allowed.
Do you have anything? Any decision?
Lordship, sir. Only aspect, Lordship.
Let me just check this one.
Okay, sir. Four, one. Very rough. 36 to 42,
36 to?
36 to 42.
Yes.
Yeah, Praveen sir. Yes, Praveen sir there. 36, why it is difficult, except for the fund, except for whether the finding palpably wrong. Manifestly erroneous and demonstrably unsubstantial. If the court answers the above question in the negative, the order of acquittal is not to be disturbed. Conversely, if the acquittal court finds that for reason the order of acquittal cannot be sustained in view of any of the evidence, can then only reapprise the issue arrive at the. There is nothing to show that they have a prima facie case. And there is what
There's, the view taken by the trial court is based on evidence. It's a probable view. This court is not going to change that. This court will only interfere. Suppose you would have made out a case of complete miscarriage of justice or inadmissible evidence or no evidence,
procedural lapses.
then perhaps the court will.
I believe in, had it been a revision, probably yes, but
No, no. For this court to grant you the leave, because this is ultimately against an acquittal. The principles are now well settled. At one time, it was thought that an order of acquittal could be set aside for substantial and compelling reasons only, and courts used to launch on a search to discover those substantial and compelling reasons. However, the formula of substantial and compelling reasons, good and sufficiently cogent reasons, and strong reasons, and the search for them were abundant as a result of the pronouncement of this court in so and so. In so and so, this court has consistently recognized the right of the appellate court to review the entire evidence and to come to its own conclusion, bearing in mind the considerations mentioned by so and so. In so and so, occasionally phrases like manifestly illegal, grossly unjust have been used to describe the orders of the acquittal, which warrants interference. But such expressions have been used more as flourishes of languages to emphasize the reluctance of the appellate court to interfere with an order of acquittal than to curtail the power of the appellate court to review the entire evidence and to come to its conclusion. In some cases, it has been said that to the principles laid down in so and so may be added the further principle that if two reasonable conclusions can be reached on the basis of the evidence on record, The appellate court should not disturb the finding of the trial court. This, of course, is not a new principle. It stems out of the fundamental principle of our criminal jurisprudence that the accused is entitled to the benefit of any reasonable doubt. If two reasonable, probable, and evenly balanced views of the evidence are possible, one must necessarily concede the existence of a reasonable doubt. Here, he has proved it. He's brought it that there is a transaction going on for years. Several payments have been made. Definitely, this is a probable view. What is wrong in this? This probable view is based on evidence.
And it is not that accused has been acquitted. When thereafter,
All right. Anything to add?
Lordship, only thing is at the stage of leave, Lordship, my only humble prayer is that
Why should this court grant leave when this court do not find any merit in this leave application? There is no merit. Your appeal has no merit. If you grant this leave, there is no merit. Hmm.
Lordship, otherwise, just one
Yes,
thing.
yes.
Otherwise, Lordship, since at the stage of leave, I have to prima facie satisfy Lordship that is there, absolutely. But Lordship, what I was proposing was, my prayer was that since there is a criminal appeal
No,
pending,
this
Lordship,
court is not concerned with that status. If that criminal appeal, anything happens against any one of you, you know your remedies.
ideally,
That has no bearing. He has not challenged the findings as regards the acquittal. That appeal is only limited to
Conviction.
paragraph 66, I think. Correct? Of course. Why would he challenge the favorable findings of acquittal?
otherwise that record should be brought before this honorable court and there should be
For
one
what?
investigation.
For what, Mr. Kothari?
Since
For what?
two parallel appeals in different forums, otherwise.
No. That is a different, he has a right. Anyway, this is item number
This 10 lots.
heard Mr. Y. Kathari, learned counsel for the petitioner. Stop also heard Mr. S. Varali, learned counsel for the
respondent number one.
respondent number 1, and PP is there. No, your name is not shown, but I'm sure PP has to be there. You're there, Mr. Lockhart? Yes, for R2 Lockhart. Yeah. This is an application under section 3783 and section 3784 of the criminal procedure code, seeking leave to file appeal against the impugned judgment and order of acquittal dated 16/5/2016, passed by the Court of Judicial Magistrate First Class Kamrup M. Guwahati, whereby the accused was acquitted under section 420 and 506 of IPC. The brief facts of the case is that paragraph 1, 2, 3. Page 2, bro. One, two. After hearing the evidences and conclusion of the trial court acquitted the respondent number 2 from the charge under section 420 and 506 of IPC and convicted the accused respondent number 2 under section 403 with a fine of rupees 5,000 in default to undergo simple imprisonment for 6 months. Respondent number 1, situated thus, the present leave application has been filed by the petitioner stroke complainant as regards the acquittal of the respondent number 1 under section 420 and 506 IPC. Stop. Mr. Kothari, learned counsel for the petitioner, submits that the judgment and order of the trial court acquitting the respondent number 1 from the charges under section 420 and 506 of IPC is manifestly erroneous and manifestly erroneous. Full stop. He further submits that the trial court has failed to appreciate the evidences in its proper perspective, especially to the fact that the respondent number 1 has removed the signboard of the shop later on. Stop. Correct? That's it. That
Like a receipt is proof, non-payment is proof, and removal of
he further submits that the receipt of the goods in question, comma, non-payment of the same, and the removal of the signboard having been clearly proved, the offenses under section 420 and 506 of IPC is clearly made out, and hence the judgment of the trial court acquitting the respondent number 1 from the aforesaid charges is palpably erroneous. Per contra, Mr. S. Bharali, learned counsel appearing for the respondent number 1 submits that the trial court, after appreciating the evidence on record in its correct perspective, has held the respondent number 1 not guilty for charges under section 420 and 506. 506, right? IPC. He further submits that he further submits that the evidence on record clearly indicates that the trial court has taken a probable view on the basis of such evidence, and hence there is no merit, and hence there is no merit in the leave application filed by the petition. Heard, perused. It appears that the trial court has how many prosecution witnesses? It appears that the prosecution adduced 4 prosecution witnesses, whereas defense examined one defense witness, apart from explaining the incriminating circumstances during his 313 examination. 3 CRPC exam. Stop. It appears from the evidence of PW1 that on 25/2004, the respondent number 1, accompanied by a broker, approached the complainant and introduced himself to be a big businessman from Agartala. It further appears that the accused respondent expressed his intention to purchase sugar on credit and promised to pay the consideration amount within a fortnight. It further appears that on such assurance, 850 bags of sugar were loaded into 2 trucks and dispatched to the respondent number 1 accused, amounting to rupees 713,879 with the words and numerical code. It appears that the 2 bills were accordingly exhibited by PW1 in connection with the said sale. It appears that PW1 further deposed that after receipt of the sugar, the respondent 1 accused person neither came to their shop for payment nor did he contact them, and that after several attempts, when one of his staff had gone to Agartala to collect the payment, he could not find the accused, nor could he find the shop of the accused at the given address. It further comes out from the evidence of PW1 that upon inquiry, it was found that the shop used to be there, but after receiving the sugar, the accused had shut down the shop and removed the sign. It appears from the evidence of PW2 that he reiterated that the accused person had visited their shop in 2004 along with 1 broker and took 850 bags of sugar. However, did not pay the value of the sugar, and that he was not found in the address given, and also remove the sign. It further appears from the evidence of PW3 that he deposed that he similarly that he it further appears from the evidence of PW3 that he corroborates the testimony of PW1 and 2 to the effect that the accused had approached and purchased approximately 800 bags of sugar worth amount to rupees 7 lakhs so, and later on had removed the signboard of his shop. So, it appears from the defense witness. No. It further appears that when the PW1 was cross-examined by the defense, he clarified that the exhibit C series exhibited by the defense where the bills issued by the complainant stroke petitioner firm in favor of the respondent number 1 accused person on different dates of 2003. It further appears that PW1 during cross-examination identified Exhibit 3 as the road challan issued by the complainant firm stroke petitioner for supply of sugar in the year 2003. It further appears that during cross-examination, PW1 admitted the possibility of the claim raised by the defense that the accused person had dealings with his firm for crores of rupees and that the entire payment was received through 66 demand drafts. Though he stated that he could not confirm it. It further appears that he further he further admitted the possibility of the claim that those drafts were received through the account at Fancy Bazaar branch as disclosed by the RTI reply within bracket Exhibit E, and stated that there might be a possibility that the demand drafts were received as advance payment of the supply made by them. However, he denied the suggestion that 25/2004 was not the first time that the accused had visited their firm. And also denied the suggestion that the 850 bags of sugar which was sent to the respondent number 1 was damaged. Stop. It further appears from the explanation given by the accused person under section 313 CRPC that he had been doing regular business with the complainant firm since 2001, which came around 2 crores rupees in words and in number, and the amounts had been paid through 66 bank drafts, and that there is no outstanding arrears payable to the company. Stop. It further appears that by deposing himself as DW1, he stated that he knew Sarvan Beniwal is who? He knew the alleged broker since 2001 and had business transactions with him, as well as, and who is Vishnu Moore?
Owner of the company.
And the owner of the complainant firm, and Arvind Moore, and the authorized representative of the complainant firm. And that these transactions amounted to around 3 crore rupees. He further deposed that all payments were made through SBI, Fancy Bazaar, and Guwahati branches and were payable to the and were payable to the complainant firm. Correct? He further exhibits A to H in support of the aforesaid deposition. He further deposed that on 25/2004, the complainant sent 850 bags of sugar. However, after receiving the same, he found them to be damaged and had immediately called up the complainant firm and informed the same. However, the complainant firm refused to accept the same. In the backdrop of the aforesaid evidences, the trial court held as under. Paragraph 23, page 17. Paragraph 57. Okay. Uh, 61. Hold on. Till 61, page 25. Reading of the apt at this stage to reproduce section 378 of the CRPC, quote unquote. Apt also to reproduce the case of the decision of the apex court in the case of Chandrappa and others versus State of Karnataka, reported in 2007, volume 4 SSC 415, paragraph
36 to 40.
paragraph 36 to 40 to 42 is reproduced here under for readiness. Reading of the aforesaid decision, it appears that the appellate court has full power to review, reappreciate, and reconsider the evidence upon which the order of acquittal is founded. However, while exercising such power, it is imperative for an appellate court to bear in mind that in case of acquittal, there is double presumption in favor of the accused. Firstly, the presumption of innocence is available to him under the fundamental principle of criminal jurisprudence, that every person shall be presumed to be innocent unless he is proved guilty by a competent court of law. Secondly, the accused having secured his acquittal, the presumption of his innocence is further reinforced, reaffirmed, and strengthened by the trial. Thus, the paramount consideration of the appellate court ought to be to avoid miscarriage of justice. A miscarriage of justice which may arise from the acquittal of guilty is no less than from the conviction of an innocent. Hence, in a case where the trial court has taken a view based upon conjectures and hypothesis and not on evidence, a duty is cast upon the High Court to reappreciate the evidence in acquittal appeal for the purposes of ascertaining as to whether the accused has committed any offense or not. However, if the view taken by the trial court is a probable view on the basis of evidence, the judgment and the view taken by the trial court ought not be disturbed in the appeal. That being so, applying the aforesaid principles, if the evidences are applying the aforesaid, keeping in mind the aforesaid principles, it appears that in the instant case, the trial court has taken a probable view on the basis of the evidences, legal evidences available on the record. That being so, the leave application has no merit or substance whatsoever. Hence, the application stands dismissed, no cost. Sorry, Mr. Kothari. That's anything. The criminal appeal perhaps is not registered.
No, it is not registered.
Anything to be done? Leave is not done.
With an FCA. Yes, it was for.
Return case records. Return case records. I think in the criminal appeal, we can just simply say in view of this,
Only the filing number is there.
Yes.
Filing number is there. All right.
Step number 11.
In this case, I have taken step today, man.
huh?
Today, sir, I have taken step.
Today, what have you done?
Yes, sir, step I taken.
You have taken steps.
Yes. I'm sitting outside there for 11 hours.
3 days from 13 March.
Outside Calcutta.
If today the matter would have not been listed, perhaps you would not have taken the step today also. Don't make submissions before the court lightly. It was on your assurance that you'll take fresh steps as directed earlier within 3 days, isn't it? Anyway, Mr. K. Kalita, you have taken today.
Yes.
Submits that he has taken fresh steps as directed earlier by this court today. Let registry verify and place the report. Relist Friday, dear. If I find that you have not taken it today, then I'm going to dismiss this petition. Relist after 2 weeks.
Number 12. So in this matter, no, the engaging confidential energy is out of town.
Huh?
Morning I mentioned before.
Yes. Not given to you.
So I have issued the paper. I have the paper.
Your name?
SK Shetty.
Heard Mr. S.K. Chetri, Learned Counsel, appearing for the appellant.
Yeah.
And Mr. Huh? N. Ahmed for the respondent stroke informant. Informant and Mr. Parashar, APP so and so. Mr. Ahmed, Mr. Parashar, you have the paper book? Yes. Mr. N. Ahmed, Learned Counsel for the respondent submits that till date, the copy of the paper book has not been furnished to him by the registry. Let registry furnish a copy of the paper book to Mr. N. Ahmed, Learned Counsel for the respondent number 2. Respondent number 2. Relist after date the book. Yes.
In May. Item number 20.
That's extremely sorry for being absent on call.
All right. Your name?
He does.
Heard MSB Das, Learned Counsel for the petitioner. Also heard Mr. So-and-so for APP and MS. M Das, Learned Counsel, appearing for respondent number 2. It appears that this matter was listed today in the order column with the remark for dismissal as there was no representation on behalf of the petitioner on the last date I-24/3/2025. However, in view of MS so-and-so appearing on behalf of the petitioner, relist. Yes, when? This matter can be listed now for hearing. For hearing. After 2 weeks, state the book. TCR Rahi sir, right? Yes.
Item number 40.
Huh? Received. The matter is ready for hearing. Paper book required. It appearance to DD book. Your name? S. Borwa, appellant, Parashar APP and Mr. B. Chaudhary for R2 and 3. It appears that the trial court records has been received. We will list for hearing. This is of 2020. List for hearing in the usual course.
Actually, last order maybe same, the criminal abuse taken. The record, but not listed in the court case, not shown in the court.
So I'll send,
He'll by the respondent number 12. 460 of
but has registry have the registry verified this? Then I will, so this criminal appeal 4060 has not been listed today. I had to list of and some other set of lawyers appear then. Then how does it make a difference? The records are here. It appears that the case records, the original case records of session case number 336 of 2012, which was which was transmitted to this court in connection with criminal appeal number 460 of 2019, is available in the is available in the said criminal appeal number 460 of 2019. Stop. Let both the criminal appeals be listed for hearing in the usual course.
Order to.
They are connected appeals.
Connected. Both are connected.
So
One
it can be,
part for enhancement and we have.
so it can be heard together and disposed of by a common judgment, isn't it? I shall resume in 5 minutes.
Better is discussed with the.
Yes. No one is appearing. None appears for the petitioner when the matter is called. Mr. A. Ahmed, Learned Counsel for the respondent number 2, and Mr. K.K. Parashar, K.K. Parashar, right? Learned APP for the state respondent. It appears that this matter was listed today in the order column with the remark for dismissal as on the last occasion, I-28/3/2025, also there was no representation on behalf of the petitioner. However, today also, despite the names of 2 advocates being reflected in the cause list, there is no representation on behalf of the petitioner. Situated thus, matter stands dismissed for non-proceedings.
Numbers. So when you see that engaging counsel, Mr. Anup is out of town.
Mr.
Anup,
Your name,
SK Chetri.
Mr. S.K.
Chetri.
Chetri, Learned Counsel for the petitioner, submits that to Mr. N. Udin, Learned Counsel, Learned Conducting Counsel for the petitioner is out of station and accordingly seeks a short accommodation. Prayer is not opposed. Relist after video data. Yes.
The plane is already expired.
Huh?
Plane is already expired.
Sole appellant.
Follow.
Abatement.
Yes.
Your name?
Age ahead.
There's a death certificate.
Yes.
Borwa. Mr. N. Ahmed, right?
Age ahead.
Huh?
I am age ahead.
A.
Jahid.
Mr. A. Jahid, Learned Counsel for the appellant submits that during the pendency of the appeal, the appellant has expired. In support of the aforesaid, he produces the death certificate issued by the Department of Health and Family Welfare, Guwahati Medical College Hospital, GMCH, Guwahati, Kamrup, which is taken on record and marked as A, which indicates that the appellant that had expired on 20/11/2022. That being so, the appeal stands abated.
Okay.
PQ appears to be disposed of.
I am praying 2 days time.
Why?
As soon as
Huh?
Arvind counsel is not. I am.
Last occasion, there was no appearance on petitioner or petitioner. Many times the petitioner counsel is not appearing. What is this revision petition? Yes, what is your name? Mr. K. Kalita, Learned Counsel for the petitioner, seeks accommodation in the matter.
Today.
short, six, accommodation, listing of these adjournment for 2 days per year. The prayer is not opposed. Date of next week or
19.
yes,
Appeal against acquittal method. And for the accused, the TJ Mohanta is there.
That's your.
you are competent, Mr. Gogoi.
Yes, that's. February.
Huh?
February, first February.
You will come. You can start. Hmm? Sorry?
Let him come. That's very.
You read the judgment. Where is the judgment?
Page number 9.
Page number
Page number 9.
9. Yes.
And the prosecution case, is that, Sri Maheshwar Mali, PW1 on 7.
Yes. Mr. Mahanta has come. He was just starting with the judgment.
My lord,
Appeal against acquittal.
I give a appeal against acquittal, my lord. Probably only point is on presumption. 113A.
Yes.
Within 7 years of marriage, my lord. Hundred and 13, my lord.
Evidence.
Evidence.
Offense, charged offense was 304.
Yes, my lord, ultimately. 304. 306, abatement. Abatement. 498. And 306, you know, is abatement. 113A, my lord, Indian evidence.
Yes.
Presumption as to the abatement of suicide by the married woman. When the question is whether the commission of the suicide of a woman had been abated by the husband or any relative of the husband and own, shows that he's committed a suicide within a period of 7 years from the date of her marriage and the husband's own. So if it is within the 7 years, my lord, it always presumption goes to the husband. That is the law. But
No, presumption, so there must be material to show that soon before the death of a woman, such women were subjected to cruelty.
But my lord, here in this case, my lord, the law can be they say always rebuttable, my lord, that only presumption goes against the husband, my lord, but it is always, my lord, rebuttable.
You are for the
I'm comment, my lord. I'm for informed. My lord, against acquittal scope is very limited. There is just pointed out, my lord, one.
informant is the wife.
No, no.
Sorry,
Father,
father of the wife.
father of the daughter, yes. Wife.
Father of the deceased.
This.
So here now, I'm sorry, Mr. Mohanta, I'm not being able to appreciate what you want to show from
No, my
113.
lord, what I'm going to say, my lord. So I am Admittedly, my lord, I have a very weak case, my lord, against equitable, my lord. Even the two views is possible, it goes always, my lord, in favor of the my lord, accused, my lord. But I wanted to point it out, my lord, that what is 113? 113A. 113A, my lord. Suppose after the marriage, within 7 years, wife committed suicide, always, my lord, presumption goes to my lord, husband, if he is within 7 years. But that presumption always, my lord, reverted.
But that will depend on the facts of each case.
Exactly, my lord. No,
So
my lord,
if-
that
if a-
revertible, they have to, my lord, they have to point it out. That they-
Yes, but suppose here there is two views possible and one
yes,
view has
exactly.
been
That's why I'm
taken.
submitting, my lord. I'm not.
Anyway, I have not opened this brief, so let us.
Yes, my lord, I have also just now, my lord, actually,
Yes, you can.
since it is a acquittal, against the acquittal,
Let us go to the judgment.
my lord.
No problem.
Yeah.
Yes, you come to page 10 during trial.
Judgment, my lord. Yes, my lord, from the start from page 9, my lord. Prosecution case in brief that Sri Maheshwari Mali was definitely not into the against the accused person in the after machine of the decade. After the few days after marriage, the she was subject to the torture by the accused person due to physical and mental torture. 5th day of the August, she came to the house, and at the time of she's 6 months pregnant. The accused person pushed the termination of the pregnancy. After 11 days, she was again taken to the matrimonial home by the husband. Another mother-in-law, two other with the assurance that will not be tortured. But on 6/9/2004, that died because of burn injuries. On the victim of the said her exhibit 1 offense in survey that investigate the case. During the investigation, police officer previously claimed to visit the place of occurrence, recorded the statement of witness, gave issued for the postmortem examination. The dead body of the injured died in the Guwahati Medical College Hospital. After completion of the investigation, records on not PW9, CSI police submitted charge sheet against the accused person under section 3043 of the IPC. After the 304 of the IPC being exclusively tribal by the Court of Session, Lana Section is Kaspa Nonia committed the case probably by the Court of Session, Kambo Guwahati by the order by the GI case number. So, such commitment, the session case started that Lana Session Judge Kambo transferred the case to the Court of Additional Session Judge FPC number 3 Guwahati for trial. Additional Session Judge FPC number 2 Guwahati is served against the accused person under 498 by 3 IPC. The charge being the Edogata explained the accused person pleaded not guilty and the commitment claim to be tried. After establishment of this court, the session judge Kambo transferred the case is court to disposal during the trial. Prosecution examined as many as 12 witnesses. The close on close of prosecution evidence a statement of the accused person supported and cutting of the CFC accused. Virendra Kumar Das in his statement, Ekuchite has denied any demand of dowry and torture on the accused. This case is that the accused is the deceased was the his sister and the sister spent for the visit the house of on 11/2/2004. His marriage was solemnized with the accused. This is especially at the time of this was student of University Law College after about 25 days of marriage. This is shown the in prosecution prescription dated 4/2/2004 issued by Dr. Pankaj Jyoti Sharma, consultant physician, Guwahati Hospital, Guwahati by the prosecution Dr. Kostak. Earlier 2.5 ambiguous disease in the month of March that he came to the know that Mithu and the disease concept so that I'm he was taking Dr. Sharma for advice. The on being asked by the doctor that she disease and it applied that she has no complaint. He was stated that till then he was no knowledge about the mental problem of the disease. The doctor advised the state stop the medicine and advised the consultant in any problem arise. The month of May, the some unnatural behavior of the disease constantly there. 3 days their disease had to no sleep. She heard the song in loud sound and repeated the same topic so that he took her the arrangement house. His father in the arrangement vehicle took the disease to the doctor on 28/5/2004. Disease was admitted in the clinic for Dr. Pankaj Lahore, Prasan Sharma, and she was discharged on 10/6/2014. The disease was taking medicine regularly. She was again taken to the round 26, 2004, 2004, 2004. Sharma took the same. She was taken to the gynecologist from the, she was taken to the physical department of the psychology department of the Guwahati Medical College Hospital on 6/9/2004. The deceased committed suicide due to her mental illness. Accused then thus examined two witnesses. Case of the accused, case of the other accused person is total denial. It is being stated that the pending trial accused from Mathumohan Das expired for his case in trial against him. I have heard the submission of the both side in the Kerala police scanned the evidence on record. The prosecution projected a case of physical and mental torture and harassment on the victim against the accused who demanded the naughty car and received 1 lakh in a case by dowry from the victim and her relative, which lead to the victim to committed suicide. Now, point for determination whether this is Mintu Deka Das was subject to the torture by the accused person and alleged whether the accused Mintu Deka Das committed suicide due to the torture by the accused person. Decision and reason for decision. Sir Mali, the informant was as well as the other of the deceased has reports that the marriage of the deceased was solemnized with the accused with Hiran Das on 11/2/2004. Actually, on 6/9/2004, the accused person killed his daughter by setting fire on her body after pouring kerosene oil. PW1 has stated that at the time of marriage, he gave all the item of his daughter. After marriage, the accused person demanded Maudika and rupees 1 lakh. As he failed to fulfill the demand of the accused person, the victim was mentally tortured. The deceased reported that she was not allowed to follow the phone. On 1/8/2004, despite of her protest that she was taken to the doctor for termination of her pregnancy by her husband and mother-in-law. On 5/8/2004, the accused Hiran Das got to the daughter's PW1 house. Again on 15/8/2004, the husband came with the mother and their co-villager Nimol Deka and Mohan Deka take the deceased. At first, the deceased did not want to go due to the torture on her, but due to the fair promise that they will not torture and not terminate the pregnancy, his daughter went to the maternal home. But the accused persons continued to be tortured. On 6/9/2004, deceased informed him that over the phone that she is not safe and requested him to take steps to bring her from her mental home. He sent his son Mahesh and daughter Vandita to the house of the accused, but the victim was not allowed to get. On the same day, the evening Sri Vanin Das, father of the accused Hiran Das, came to the information that deceased sustained burn injury and taken to the Guwahati Medical College Hospital. Going to the medical college, we found that the dead body of her daughter. From the hospital authority, he came to know that before arrival at the hospital, that victim died. He was deposed that death of the daughter was unnecessary. The morning 7/9/2004, as I heard, that is Exhibit 1, Ramia Police Station. PW1 in course examination has admitted that as I have one, he has not mentioned that the accused person demanded 1 Maruti car on 1 lakh rupees. He has also admitted that before police did not said that the accused person demanded Maruti car and rupees 1 lakh for the non-fulfillable said demand. The accused person started to torture his daughter. He denied that before police I did not state that on 1/8/2004 the girl was taken to the termination of pregnancy. He also admitted that he know the Dr. Pankaj Sharma, Guwahati, who is a psychiatrist. He took the starter to the disease of Dr. Sharma for the treatment. He has stated that BA Part 1 examination disease got back in the one subject for which the deceased mind was disturbed. Consulting with the husband on 4/2/2000, he took the deceased to Dr. Sharma. He was stated that before the marriage, he disclosed his to accused Hiran Das. He denied that he did not disclose the accused Hiran Das. He has admitted in Exhibit 1 that the Exhibit T is the description that it 4/2020 by Dr. Pankaj Sharma. He was admitted that on 25/4/2004, he was admitted in Guwahati the psychiatric hospital and research on 1/6/2004. He had admitted that Exhibit E is the search certificate issued by the state hospital. PW2 Mansuki Das, who was the brother of the deceased, had reported that 6/9/2004, he and his sister Bonita went to bring sister from the house of the accused person. He stated that a sister told him that the top of accused person, she came to know that that she will be killed. His sister father told that for the first time he had seen the gallon full of kerosene. The accused person not allowed to come with them because has denied that before that police did not stated that on 6/9/2004, he and his sister went to bring the sister. PW3 Pandita Dekha, the sister of the deceased, has reported that after marriage, when the sister came home, told that the marriage accused person took loan of rupees 1 lakh and for the same accused demanded Maruti car. Without fulfilling the said demand, her sister was brought to was tortured. She has stated that the husband and the mother-in-law of the sister took her sister to the doctor's termination of the pregnancy against her will of the sister. And the doctor declined to terminate the pregnancy, for which the process of the sister is increased. On 5/8/2004, her sister was came to home with her husband. Her sister disclosed all the incident to him. Her father took her sister, Dr. Amita Bothapu, for check-up 2004 on 15/8/2004 at about 4 p.m. Anindya Kumar Das came to take her sister, but due to her to fear of torture, her sister did not want to go. The same day, the evening at about 7:30 p.m., husband, mother-in-law of the sister came to a local person to take her sister. The father sister declined to go, but her husband promised that they will not torture her and will not terminate the pregnancy. At this, her sister agreed to go to her matrimonial home. On the next day, that is on 16/8/2004, his sister went to her matrimonial home. On 6/9/2004, her brother PDP2 went to the house of the accused. The sister told that the first she has seen full gallon of kerosene where they wanted to bring her, bring their sister. She was not allowed to come. When she had her brother with narrating the incident to her parents, Anindya Kumar Das came to the informant that her sister sustained burn injury and she was taken to the GMC hospital. On the same day, her sister succumbed to her injury. Because she has denied that before police, she did not stated that her sister, she came to know that the accused person took loan of rupees 1 lakh for marriage. She had denied that before police stated that she did not stated against the sister was pregnancy. She has admitted that between 16/8/2004 to 5/9/2004, they had not visited the house of the accused person. She has denied that with the suspicion of material illness and her sister committed suicide. PW4, the Subsundar Dekha does not know the deceased sustained burn injury because he stated that the relation of the accused with her husband and his family member were very cordial. He has stated that his house is opposite to the house of the accused person. His wife visited the house of the accused. The deceased also came to his house. He stated that the deceased never told that she was subject to torture of any doubt. PW5, Cindy Lina Dekha, another sister of the deceased, has reported that on 1/8/2004, the deceased was taken to the doctor for termination of her 6-month pregnancy against her will by her husband and mother-in-law. But doctor did not terminate the pregnancy and advised some medical tests. But the husband of the deceased did not feel any importance to this and stated torture on the deceased. On 5/8/2004, deceased was brought to her house by her husband. Her father, PW1 again took the deceased to the medical college in Osekap. On 15/8/2004, the father-in-law came to take the sister. At first, the sister of the deceased refused to go to the matrimonial home. Then her brother-in-law gave assurance that she will not be tortured and that she will get care as a doctor. The next day, that is on 16/8/2004, the accused Hiren Das took her sister. On 6/9/2004, as per direction of her father Mohan and sister Vanita went to bring her deceased, but the accused person not allowed the deceased to bring with the sister and brother. The evening, Hanin Das informed that the deceased sustained burning. Because she stated denied that before police, she did not stated that deceased was tortured for demand of dowry. PW6, Dibakar Dekha has reported that the secondment to her burn injury was in medical police hospital. He also accompanied the injury to the medical because he has stated that his house is adjacent to the house of the accused. The relation between the deceased and her husband was cordial. At the time of the incident, accused Hirandas was not at home. On the way to the accused, on way to the medical accused, Hirandas informed to remove police outpost about the occurrence. PW7, Jatin Chandra Dekha, who was the neighbor and relative of the accused, has been reported that at the time of occurrence, the accused Hirandas was not present. He was informed accused took that into the PW6, Onima Haloi and mother of the accused was reported that on 6/9/2004, she sent her son to the Manas and daughter Pandita to house of the accused to inquiry of the health of the deceased. Seeing the deceased on the same sad mood, they wanted to bring the deceased with her, but the deceased was not allowed to come. After a few minutes of their arrival from the house of the accused person, younger brother of the accused then informed that the deceased sustained burn injury and she was taken to the Guwahati Medical College Hospital. She with her husband and her mother-in-law Nayan Leka went to the medical college hospital. They saw the dead body of the deceased on the bed of the hospital. Accused Hidendra, his sister-in-law and some village people were present and near the dead body. She has stated that after marriage, when the daughter came, she told that she was tortured. She told that accused person demanded 1 lakh Maupikar and rupees 1 lakh. She was also not given proper food. She PW8 reconciled her and sent her to the maintenance home. She has also stated that she is also told that on first day of August, Finland, and his mother took her to Dr. Anita Pothako for treatment for pregnancy, but due to the presence of the deceased, doctor did not terminate her pregnancy. At that time, the deceased was advanced stage of 6 months after the death. Remember, the kid was a bigger poster, it by 5th day of August, the got deceased to the house and asked not to return the matrimonial home on 15th day of August. Anindanda's brother refused when they came to the deceased, but the deceased refused to go to him with the family. The same day at about 7 p.m., accused Hiranda went with the mother and two village people to take the deceased. The deceased was not willing to go, but accused promised that she will not torture. On the next day, accused took him to. She has stated that as she did not give any information to the accused after 16th day of August, also 6th day of September, they sent Manos and Pandita to house of the accused. Because she has stated that when the deceased received the accused, came to her Dr. Anima Aina Bothaku for checkup regularly. She has stated that the deceased was taken to Dr. Pankaj Losul Sharma for treatment for her mental distress when she got back on subject on clear part 1 examination. She had denied that the mental depression of the deceased committed suicide. PW9, Jagat Chandranath, SI police only collected the supplementary case diary and submitted charge sheet and exhibit 2. PW10, Bapuram Polita has reported that on 7/9/2004, he was working as a officer of the Romania PS. On that day, officer in charge, Syrian Azhar from Mahashar Mali, and endorsed him for investigation for the comment PW1. Came to know that the injured Mintudas died at the Guwahati Medical College Hospital, so he gave requisition for postmortem. Along with the other officer in charge, we went to the place of occurrence, situated in Baburka village, recorded a statement of witness as the got the order of transfer. He handed over the case to the officer in charge because he stated that the informant PW1 did not state before him that deceased was subject to the mental and physical torture of the. He has also stated that the PW1 was stated before him that on 18th, the deceased was taken from medical termination of pregnancy. PW1 has not stated that the PW1 sent his son Manas and after Babita from the PW1 has also stated that the informant did not state before that the accused person increased the degree of torture when the deceased refused to consent for medical examination. PW1 had not stated that the deceased is subject to the torture immediately after the marriage, as he failed to fulfill the demand of the Mahutika, which is 1 lakh. PW10 has also stated that PW3 has not stated before him that the accused person demanded the Mahutika card and refused 1 lakh. PW3 has also not stated that in 6/9/2004, as per direction of the direction of her father, she went to the house of the accused person with her brother to the being consistent. She has also not stated the accused person demanded 1 Mahutika and PW3. He has stated before that she herself committed a suicide. The PW3 has also not stated before PW10 that on 15/8/2004, the evening accused Hiranda with his mother and 2 village people came to their house to promise that they will not torture on the deceased. PW10 further stated that the PW8 murder of the deceased has not stated the accused person demand 1 lakh or PW11 Dr. Amol Jyoti Patwari who did the postmortem examination of the dead body now into that on 7/9/2004 Guwahati Medical College Hospital. That is which the CMC outpatient has reported that the death of the deceased was due to the shock and result of the burn injury involved in the whole body except the lower part of the posterior aspects scalp, which was an antemortem caused by the same burn involving 98 of the body surface area. He also proved that the postmortem examination reported this mark of exhibit 4 element signature of the PW12 that Suranjana Senapati did the inquest on the dead body that was casualty uninjured KMCSM reported prepared the report exhibit 5. PW1 Dr. Anna Bothakur, a consultant gynecologist at the Bothakur Guwahati has reported that she known accused Dr. Virendra Das on around 14/6/2004. Accused Dr. Das brought his wife Mintu Das for internal checkup pregnancy against on 1/8/2004. Accused brought Mintu Das deceased for checkup and examining her and prescribed medicine also advised to her for per diet. The GP is the prescription issued by her. She has stated that on 1/8/2004 pregnancy was 24 in course. She has stated that she examined into the app at Bothakur clinic, but exhibit F is not the bed of the Bothakur clinic. She has stated that at the time of examination, mental condition of
Mr. Mahanta, I have read it.
my lord. Obviously, my lord, very difficult for me because Dr.
See, because
It is admitted that she has a
now,
fantastic
undoubtedly there is a presumption
that is-
which can in a certain case be drawn. But
Correct.
but that presumption cannot be drawn automatically, isn't it? It is permissive. Now, before drawing that presumption, the prosecution must prove few things.
Exactly, and not only that, my lord, they also get to, my lord,
Correct,
debate.
that they have already
Yes.
reported. We cannot say they have not
That's why
reported.
I'm-
They have brought the witnesses to indicate that the deceased was going through a mental
And that's that part, my lord.
that part, whether it's a probable
I agree, my lord.
but where is the evidence of cruelty?
That part, my lord.
That is something which you must first prove.
Exactly. my lord.
Only when that is proved by the prosecution and of course the other condition,
Other
then only the
condition?
presumption will come.
From the evidence of the, my lord, IO, it is clear that, my lord, that was
Not stated during
not
161
speak before the IO.
before the IO
Yes.
in the initial deposition.
Fine.
Even in the FIR, all this is not there. The demand of Maruti car.
That is
Not
not
there
there,
in the
that is,
FIR.
it is, my lord, improved in the evidence, my lord, but that part was also not, my lord, placed because when it was crossed the IO. That he specifically said that was
He
not,
said-
when I was making
said-
inquiry 161,
no,
that
no.
was not there.
You see, PW1 only said that in his Vijahar he has not stated. He admitted that.
That's why, my lord, it's the case they could, I told him that, my lord, very weak case, my lord. But nowadays, my lord, it's very difficult to, my lord, concede me, my lord, but that's right. That legal evidence I have seen, my lord, that before marriage, she has been mental depression, she was been admitted and
These have been proved,
that,
and the court has taken one view.
Right.
Now, while exercising jurisdiction in an appeal against acquittal,
very,
this
very,
court-
very.
if this
scope is
court
limited.
finds, if this court finds that the trial court has acted on no evidence, of course.
That's
But if the
fine.
trial court has
I'm finding it
acted on
barbara and
evidence,
costly
which
misconduct.
is also legal evidence, then merely because another view is possible will not be sufficient.
Then even another view is possible, then it will go in his favor. in his
Correct.
favor.
Yes.
But in this case, my lord, the trial court has given a very reasonable. And my lord, if you go to the evidence also, my lord, it has been proved that my lord, she has some, my lord,
Mental.
illness was.
And the neighbors have said that they have a
Their
cordial,
participation was cordial, my lord.
those are prosecution witnesses.
Yes,
20 is not proof.
yes. Cruelty has not been proved. First year, my lord, cruelty has to be proved. Then, my lord, the presumption of 113A will come back.
Correct,
Whether within 7 years, his husband and their family
Correct.
members have tortured.
that cruelty has to be proved. One of the ingredients is to prove this cruelty. Without that being proved, automatically presumption cannot be come.
Yes,
Anything more?
that is my submission, my lord.
All right. Ulwa. Anything?
No, my lord.
Heard Mr. T.J. Mohanton, learned senior counsel, assisted by Mr. T. Gogoi, learned counsel appearing for the appellant. Stop. Also heard Mr. B. Chaudhary, B.M. Chaudhary, sorry. Mr. B.M. Chaudhary, learned counsel appearing for the respondent.
There are 4 respondents are there, but one is direct.
So you are appearing
For all the rest.
for the respondents, and PP is there, and Mr. Locker, learned PCP for the statement. This appeal is filed under, this appeal is preferred under section 372 of CRPC 1973 against the judgment and order dated 13/12/2012 passed by the learned additional session judge within bracket FTC Kamrup Rongia, hereinafter referred to as the trial court, in session case number 38K within stroke 2007, whereby the accused respondent was acquitted from the charge under section 498 within bracket A stroke 306 of IPC. Accused persons, accused and respondents. The brief facts of the case is that the is that on 7/9/2004, the appellant lodged an FIR before the jurisdictional police station alleging inter alia that on 11/2/2004, his daughter, within bracket hereinafter referred as deceased, was married to the accused appellant Dhirendra, appellant number, respond to the accused respondent number, not 1, 2.
One is state of
State is the respondent number 2, huh? It's accused বুলি ক'লে R2 ক'বা, accused respondent number 2. And after a few days of marriage, she was subjected to torture by the accused persons. And due to such torture, no, not due. Stop. It was further alleged that she was pregnant. However, the accused number 2 was forcing her to terminate the pregnancy, which she refused. It is further alleged that on 6/9/2004, the deceased died because of burn injury. Accordingly, the FIR was registered as Rongia PS case number 336 of 2004 under section 304B of IPC corresponding GR case number 68504. After the investigation was completed, the investigating officer submitted charge sheet against the accused respondent. Anything?
no, no.
Against the accused respondents, respondents. under section 304B of IPC. Accordingly, the matter was committed to the Court of Session, to the trial court. Whereafter, the trial court framed charges against the accused appellant under section 498 within bracket A and 306 of IPC. Sorry, accused respondent, huh? Change code. Because I am so used to accused appellant that I The prosecution examined as many as 12 witnesses in support of their case, whereas the accused respondents examined 2 witnesses in their defense. Thereafter, upon conclusion of the trial court acquitted the accused accused respondents by judgment and order dated 13/12/2012 from the aforesaid charges. Situated thus, the present appeal has been filed. Mr. T.J. Mohantam, Learned Senior Counsel, submits that under section 113A of the Indian Evidence Act 1872, in the event a married woman commits suicide within a period of 7 years of her marriage, it shall be presumed that her husband has abetted her to commit suicide. Stop. He further submits that it is not the. He further submits that the rebuttal. He further submits that it is for the accused to rebut such presumption by adducing cogent evidence. Correct? Correct. He accordingly submits that since the aforesaid presumption has not been rebutted by the accused respondents by adducing cogent evidence, the judgment and order of the trial court acquitting the accused persons from the charged offense is palpably and manifestly erroneous. Stop. Per contra, Mr. B.N. Chaudhary, Learned Counsel for the respondents accused, submits that the judgment and order of the trial court being based on legal evidence, no interference from this court while a court is warranted. He further submits that the trial court, upon considering the evidence and other material on record and analyzing the same, has passed a reasoned order, has taken a probable view in the matter which ought not be disturbed by this court under section, what is the provision? The appeal against equity under section 378, 372 of CRPC. Heard, perused, It appears that the prosecution has adduced the evidence of 12. No, it appears that the though the prosecution witnesses, especially PW one, PW two, PW three, PW five, and PW eight, who are the parents and sisters and brothers of the deceased, deposed that the accused respondent subjected the deceased cruelty and demanded a Maruti car. No, subject demanded a Maruti car, which, being not fulfilled, subjected her to cruelty. Maruti car and rupee 1 lakh. However, upon perusal of the evidence of the investigating officer, PW 10, right? PW 10, it appears that the investigating officer clarified during cross-examination that these witnesses, when were examined under section 161 CRPC, they did not mention that the accused persons demanded one Maruti car and rupees 1 lakh as dowry, and non-fulfillment of the said demand, the accused persons subjected the deceased to cruelty. It further appears that the other prosecution witnesses, PW 4, 6, and 7, who are the neighbors, and has come and has visiting terms with the accused respondent, has clearly clarified during cross-examination that the relationship between the deceased and the accused persons were good. It further appears that the defense witness number 1, who is a consultant gynecologist of Bhakur Clinic, has deposed that she was examining the deceased regularly upon being brought by the accused number 2, while she was pregnant. It further appears from the testimony of DW number 2, who is a psychiatrist was treating the deceased since a long time, since a considerably long time, as she was having as she was mentally ill. It further appears from the testimony of DW2 that the deceased was suffering from bipolar affective disorder mania. It further appears that relevant documents as regards prescription and hospitalization and discharge thereof in connection to the said mental illness has also been exhibited and proved by the aforesaid DW2. If I'm not wrong, I think PW1 has admitted this discharge
Yes.
in his cross, right?
DW.
Who has, no, PW, I think also. Someone admitted in his cross. Huh?
DW1.
PW1, right?
Other.
Yes. Which paragraph was that?
Activity at page, Lottery will find at page 13. There, my lord. He has admitted that exhibit E is a prescription.
Yes. So this is PW1, right?
PW1.
It further appears that PW1, the informant, the informant struck father of the deceased, admitted exhibit D as exhibit D, which is the prescription dated 4204 issued by DW2, and also admitted that on 25/24/2004, the deceased was admitted in Guwahati Psychiatric Hospital and discharged on 10/6/2004. The relevant and also admitted exhibit E, which is the discharge certificate issued by the said hospital. It is based on, no, it appears that the trial court, after analyzing the evidence on record, has held the accused respondents not guilty of the offenses charged. F to reproduce paragraph F to reproduce the operating paragraphs of the aforesaid judgment on page 19 of Balopa. Take it from page 18. A, huh? A, 2, into A, page 21. Or page 22 again. Into page 22. Huh? Okay. Reading of the aforesaid judgment of the reading of the aforesaid judgment of the trial court, it appears that the trial court has taken a probable view on the basis of the evidence on record. As regards the argument of Mr. T.J. Mahantol and senior counsel, as regards the presumption to be drawn against the husband, as per section 113A of the Evidence Act, comma, mere fact that a married woman commits suicide within a period of 7 years of her marriage is not sufficient to draw such presumption unless and until it is shown that her husband or any relative of her husband has subjected her to cruelty during such period. Stop. As seen, there is no evidence of cruelty established by the prosecution in the instant case. Stop. That apart, the powers of this court to reappreciate, review, or reconsider evidence and interfere with acquittal are well settled. Apt to reproduce paragraph 36 to 42 of the decision of the Apex Court in the case of Chandrappa and others versus State of Karnataka, reported in 2007, volume 4 SSC at page 415. Quote unquote. Reading of the aforesaid judgments, it is apparent that if the appellate court, if the trial court acts on evidence to acquit the accused persons, comma, the appellate court shall not interfere such findings of the trial court. Stop. Hence, I am of the considered view that the trial court, having acted on evidence and having taken a probable view on such evidence, the appeal lacks merit and substance whatsoever. Accordingly, the appeal stands dismissed. Sorry.
It's all in my life. What I say.
I am not placing this matter because the petitioner has already expired.
So it will be closed or abetted. Mr. Locker, revision petitioner expired, so it can be closed. Your name?
M. Bhattacharjee.
M. Bhattacharjee for petitioner and M. Sharma for respondent numbers 1 to 5. And Mrs. M.S. So-and-so, Learned Counsel for the petitioner submits that during the pendency of the criminal revision petition, the petitioner expired on 5/12/2024. In support of the aforesaid submission, she produces the death certificate issued by the Department of Health and Family Welfare, Office of the Chief Registrar of Births and Deaths, Guwahati, Government of Assam, which is based on record and marked as X. In view of the aforesaid endorsement, the criminal revision petition stands closed. Yes, Mr. Gogoi?
Yeah, in this matter, you know, my senior was engaged by the teacher program.
Hmm.
Expired.
Huh?
Oh. Expired. Now.
You, realize that? Put on like, it's not very clear. We have written letter.
Yes.
You have not.
Basically, instance.
What is to be done?
The location of the petitioner.
You argue the matter.
Done, but have no instruction from Shipman.
What instruction you need in a criminal
by the-
petition?
Actually, it was engaged matters. So
Correct, but you don't need any instruction in a criminal matter.
it's a complete
Interim order is also continuing. PCR has come. PCR is now, isn't it?
Yes, sir. Okay. Well, 2 weeks time.
Huh?
2 week time.
All right. Because you see, the 2013 matter, we don't know whenever notice is given, how, when it will come, what will happen. You are the engaged, Mr. TJ Mahanta name is otherwise on there, isn't it? The engaged council, I understand. Perhaps. Anyway,
Have no indirect communication, senior advocate.
you don't need, you take it.
My name is complete.
Your name, Mr. T. Gogoi. Mr. T. Gogoi, learned counsel for the petitioner, submits that his senior, Mr. T.J. Mohanto, was engaged in this matter to represent the petitioner by MSP Chakrabarti. However, she had expired last year. Thereafter, despite best efforts by the office of Mr. T.J. Mohanto, learned senior counsel, they could not contact the petitioner. He further submits that though a registered letter,
Yes.
a registered letter was also sent in this regard, intimating the death of the counsel appearing on record for the petitioner, no response whatsoever has been received by them till date. In view of the aforesaid submission, keeping in mind that this criminal petition is pending since the year 2013 with interim order operating, it would be deemed appropriate to issue fresh notice, to issue notice through registrar, through the office of this, to the registry, to the petitioner. Accordingly, let registry issue notice. Let steps be accordingly taken through registry. And registered post with AD. Relist after 3 weeks. Then appears for the petitioner on call, relist after 3 weeks on a date to be fixed by the registry. Who is appearing for the
MK Chaudhary, so the engaged counsel.
his quashing proceeding of the complaint case?
Yes. They had filed a petition before the trial court asking to drop the charges.
None appears for the petitioner on call. MS P.
Gupta,
Gupta, Learned Counsel, is present for respondent numbers
1 and 2.
1 and 2. Relist when
Next week,
schedule to Silog, নহলে তার next week করবে।
5 August.